that file I gave you, the bench form, I
Yeah.
did not call the attorney yet,
Okay.
just so you know.
Yeah, I'll take care of it, definitely.
It's cool enough, but it's warm. Yeah.
Yes. Okay. Okay, yeah, we're going to get over Yeah, so I would actually probably be looking at how about Tuesdays, Wednesdays, Thursdays, how about that work? That's like they want extra time, that's a Wednesday. So, and that's the only thing I want to ask her. Yeah, I don't want to do it like
far as my career has sunk of being covered by Charlie Lang.
over us? Nothing to do with you.
I work for the free press and they pay for it. Yeah. It's like $100. Oh, I know. No, it's like $75 to renew, and then it's $100 an entry for entry, and then if you get nominated, it's a banquet. It's like two something. It's crazy. It's money grab. Yeah. I just do it because it's free. Yeah. Yeah. Yeah, it's true.
Before us even. Yeah.
Really?
Oh, their cushions are hard. Their cushions are hard.
Chair, right?
Even not having court yesterday. Huh. See Chief's tie?
Yep, he wore that.
They really? Oh.
He wore that.
I always believe it. Once you're watching, attract attention. Especially for the yeah.
That's what he said this morning. He came in and he looked at Rich and he goes, "Where's Hank? We all know where's Hank."
Yeah. Oh, Rich is not pink, huh?
We almost went to the store and bought one last night. It was kind of a rough night, so we didn't make it.
Well, I could have bought you a pink tie.
He'd have worn it. It has. I'm imagining you guys are quite exhausted. I know.
Like, what were we doing? Oh.
That's red button.
So glad you went, though. This was exactly what you needed to do.
Wow.
Does it work well? I asked.
Give myself the best advice.
Bill?
Well, you got a lot of people here calling for you today, honey.
Yeah. Said when I walked in, it's full house.
Kind of beautiful group back here. Team colors. It's the only one I take a picture.
Thank you, Johanna.
This team is amazing. These folks are all of them.
Everybody.
The cameras are going to be good in now, so just so you know, they're picking up their voice.
Yep.
Yes, Your Honor.
Yes, Your Honor.
And for the audience sake, sit down, relax. There are many signs out on that front door that say no cameras allowed. No cameras are allowed except the media who's already given me an order. Please do not stand up during these closing arguments and take snapshots and put it on your Facebook. That's not what this is about. Respect the attorneys. It's very difficult for them. They got to remember a whole lot of things, and to have you walking around taking pictures is an annoyance to them and a distraction. So please respect them. They work really hard, and also respect this process. So unless you're part of the media, if I see you with the camera, if I see you with a cell phone, the deputies will immediately take it from you. So, don't come squawking when that happens. I'm giving you fair warning. Also, please keep your traffic down in and out. I understand if you need to leave in between, that's fine. But please try to keep that at a minimal, because that's also very distracting to the attorneys when they're giving their closings. We are ready to proceed, and apparently Mr. Daly and Mr. Sheik, there is an agreement that you are going to allow for the admission of a few more documents.
Judge, we have some documents on People's Exhibit 186, 187, and 188. 186 is sport tracker data, 187 is call detail records, and 188 is drive test data. These were all previously given in discovery, and I also provided an additional copy to counsel this morning. And yes, we are asking the court's discretion to allow us to admit those at this time by stipulation.
I know we did receive them, we did review them, and we did discuss them. We have no objection to
And
them
that
being
is,
admitted.
that is 186 and 87.
And 88.
Okay, you're going to need to do that again with the jurors when they come in,
I will
so
do
that
that.
they know that they've been admitted.
Yes.
And I guess we're ready to proceed. Anything else?
No.
I do have my jury instructions, and
Yes.
you are in agreement with those jury instructions?
Yes, we are, Your Honor.
Okay, bring the jury out. And I think we're going to need to take a break after the opening from the prosecutor. Give you about 10 minutes. I have a juror that's indicated they may have some issues, so we'll take a break after the prosecutor, and then we'll proceed with you.
Thank you, Your Honor.
Good morning, everybody. Welcome back. Hope you enjoyed your day off yesterday. Are you ready to get back to work? Okay, we're going to begin with the prosecutor making their opening statement, and after he makes his his closing statement, we will proceed then to take a break, and then we'll listen to the defense, and then the prosecutor gets to rebuttal. Mr. Daly, apparently there was an agreement reached between you and Mr. Sheik regarding some evidence.
Yes, Judge, and just for the jury's edification, there are 3 additional exhibits. They are records. 186 is sport tracker data from April Millsap's phone. 187 is call detail records from the defendant. 188 is drive test data that Special Agent S used, and they're all admitted by stipulation.
That is true, Your Honor.
And they've all been admitted. Thank you. Are we ready to proceed now, gentlemen, with your closings?
Yes.
You may begin.
Medieval times that we know now as the dark ages, a familiar was spirit that was embodied in the form of an animal to protect and serve its owner, master.
Keep your voice up, please.
Think, if you will, Harry Potter. Harry Potter's familiar was his owl, Hedwig. In this case, Penny was April's familiar in life, and her iPhone is her familiar in death. Penny showed us where the body was, but the iPhone told us who her killer was. And her iPhone told us it's James VanCallis. What did the iPhone tell us? First, it told us where she was murdered. We have that GPS on the path. Second, it told us when she was murdered, at approximately 6:30 or 6:31 on July 24th of 2014. It told us where to find her backpack. As you saw from Agent Zent's recreation through that blue line on that visual, how the motorcycle went up through the path and crossed back into town. And just as importantly, it told us who did not commit this murder. This murder was not committed by somebody on foot. This murder was not committed by somebody riding a bike. Because as you know, people like Landon Buchanan, who ride regularly, got to a maximum speed of approximately 17 miles per hour. The Zent's GPS graphic showed you that the average speed was 34 miles per hour, spiking towards 40. We know it wasn't a white van because there was no white van seen on the path or anywhere near the Orchard Trail. And it damn sure wasn't a border collie. What it was a motorcycle. James VanCallis' motorcycle. A motorcycle you've come to see during our proofs, and I'm going to show you in an uninterrupted fashion, that was so unique in its modifications that it became a fingerprint, that it became unique. And that unique fingerprint is owned by James VanCallis. That motorcycle was at the murder with James VanCallis. He was the one who brutally, without reason or shame, stomped April Millsap to death. We know that because the cycle took a path that no other vehicle could take. And we also know that the person that was riding that motorcycle was unique in his knowledge of the area. Because when you see that upper part of Exhibit 33, which I will show you, there's only one road that leads you to Armada Ridge. And it's amazing the number of turns that were made and specifically went to that road. And when the bike from Cost matches the bike at the gas station, which the defense has indicated is James VanCallis, matches the one that we took, is there any doubt left? It told us where her phone could be found, and it also took us past that line, even though Cost turned over that video. The Zent's graphic shows us the picture and confirms the other pictures from the Marathon gas station that it is the right bike. And we're going to show you those pictures in a few minutes. I'm also going to show you rear pictures, and we're going to compare on high def the motorcycles, the unique fingerprint owned in this case by James VanCallis. But first, let's talk about the premeditation aspect of first degree. There are 4 charges. The first 2 that I want to deal with, and what we're going to deal with right now, is premeditated murder. The instruction is an instruction that you've already received a couple of times, and is going to be read to you, it's going to be handed to you. This was Hollywood. Or maybe if I decided to carry the thing, but I don't. The first ones are basic. Cause of death of April Millsap by blunt force trauma and asphyxia. We'll talk about that in just a second. Number 2 is that it was an intent to kill Millsap. There's no doubt about that. Number 3, again, with premeditation. Number 4 is the one that I really want you to consider. I'll read it with you. The killing was deliberate, which means the defendant considered the pros and cons of the killing and thought about and chose his actions before he did it. There must have been real and substantial reflection for long enough to give a reasonable person a chance to think twice about the intent to kill. The law does not say how much time is needed. That's for you to decide. We talked about that can be as little as seconds or as long as it took to plan the 9/11 bombing. That's up for you to decide. We're going to talk about that 3 to 5 minute gap, which is where the premeditation was formed in just a second. Killing cannot be the result of a sudden impulse without thought or reflection, and that's going to go to the second theory that we have about the amount of time it took to commit that murder. But going back to the facts, it's sort of hard to lay out what our theory is. Can we go to black on that for just a second? It's kind of hard to lay out the theory in opening statements or through witnesses when you have to constantly have the back and forth. But let me construct for you how we look at the evidence and how this crime happened. The information also that we learned from her phone, which is critical, is that text at 6:28. I almost got kidnapped. OMFG, oh my effing God. That tells us very clearly that prior to that text that she said to Austin, she had been assaulted. She had been confronted. She had in some way likely been grabbed and escaped, because if you follow Zenz's path, when she is coming down that path, she's going 2.2 miles per hour. When she turns around and heads back, she's doubled her speed to 4.4 miles per hour. All of the witnesses told you, and we'll see you just in a second on another graphic, that they all thought the same thing. She was tense. Something wasn't right. They all said there was something wrong. He wasn't successful that first time. He had to come back and try a second time. That's what's critical. That 3 minutes between 6:28 when she made that text to the point where she got just past the Liberty Trail at 6:30 to 6:31. He figured it out. How is he going to do it? This time he grabs his helmet. He hits her on the top of the head, at which point the helmet falls. Her phone goes to the ground. You saw the distance that he had, that very short time distance in that tunnel of trees. He's got to get her off the path at this point. So now he picks up the phone, he puts it in his pocket, he picks up his helmet, and he picks up her. She's also dropped the leash because you've seen the picture and how small she is. This helmet, you saw from Dr. Petrangelo in this spot here, knocked her silly, blunt force trauma right there in the face. He has to grab her, the phone, and the body, and he hauls it into the crowded area, that one small space. But now he's got two problems. Number one, he's got her phone in his pocket, and he's got the dog. In dealing with the phone first, those 3 phone numbers mean nothing to this case. You heard Detective MacArthur. She looked at 7 months worth of records of VanCallis and April. April only had one 810 number that she dialed. That number goes to a company that isn't using that phone number. It exists, but it's not answered. This is a butt dial. Every one of us that has an Android phone or a phone with this sort of face has done that. We've dialed somebody and we didn't know. We either hit redial or it came up with a new number. That's what those 3 numbers represent. No connection whatsoever to this case. But now he's got a second problem. He knows when he has taken her off the path that she may still at some level be alive. So when he brings her over, first thing he's going to do is stomp her. All about her head, all about her chest. Because he can't afford to have her get up now. He can't have her get up and identify him or start screaming. He knows that path isn't completely empty just by the 5 witnesses we brought so far. That's about all the other ones. There were people on that path that could see him. He had to silence her so that she wouldn't scream out and have him get caught. But now he's got a second problem, and that's the dog. And that dog, though she may not have been able to prevent the death, as April's familiar, my God, she wasn't going to leave her to die alone. That dog probably whimpering, at which point now, remember on Zence's text, remember his graphic, when the motorcycle had left, there were two places on the road that came to a stop for 30 seconds. One before Cross's house, then one just out of Cross's range. And if you remember on that graphic, when that motorcycle is still, when that phone is still, it didn't move. But remember, when that 14 minutes of that murder, that phone was going like this. What's he doing? He's chasing down the dog. He knows he's got to silence that dog, or that dog is going to alert somebody on the path that he's there, and she's almost dead, and he wants to rape her. He doesn't want to get caught. So he's probably at some point able to grab the leash on the dog, but like most dogs, if you have just a regular leash, it's slipped up over the head, because when Penny is found, there's no collar and there's no leash. He had gotten it. But probably by now, Penny is simply whimpering. So one of those little squiggles, he probably goes back to the path and looks left and right to see if anybody's coming. And nobody's coming. So he goes back and he starts to do what he wanted to do all along. First thing he does is he comes up, he grabs her shoes, and just throws the shoes behind him. Goes up to her top, pulls that tank top down, takes that bra, rips it off, moves down to her pants. Starts to unbutton them, pulls her pants all the way down. Here's a sign. He sees Amy Spinella. Remember Amy's testimony, she saw the eyes. He looked like he had his hands in a cookie jar and got caught. That's why they're like this. Because that's what he does. Now he knows he can't stay. Now he knows he can't finish. Because he's been seen. The panic starts all over again. So he grabs her iPhone, grabs her backpack with all the stuff in it, grabs her leash, grabs his helmet, gets on his bike, and he leaves. Drops the backpack off. Conveniently goes around and gets out of the scene. You had a rare opportunity in this case to see something most juries don't get to see. And that is, you got to see Mr. VanCallis' volatility. Remember when Bill Buchanan was standing here and they were doing that god-awful supposed test, which we'll talk about in a few minutes, because I find it odd, because here you are lower than he is, and you're supposed to be able to see up over that, okay? God. Anyways, Bill Buchanan is standing here very quiet. He's going, no, you've got to put the helmet on. You've got to pull that helmet down. Now the helmet's too high up, you've got to pull that helmet down. But here's VanCallis. I brought it that way! Shut up! Put it in these terms. In front of 12 people, 14 of you now, 12 people who will eventually decide his fate. In front of 4 armed deputies. Remember, we had to remove you before we brought him out and get more security, because it's very difficult to bring somebody accused of murder that close to a jury. 4 armed deputies. 2 more armed investigators behind me. 3 cameras showing this case to the world. and when things don't go his way, and when Mr. Buchanan tells him, no, you're doing it wrong, what does he do? He turns around and he yells at the judge. So you tell me, what chance did April Millsap have as a small 14-year-old girl on an isolated stretch of the Orchard Trail when she rejected his advances and told him no? It earned her being stoned to death. So, what is... hold on a second. So let's go back now to... Put the phone thing back up, if you would. Let's go back to premeditation. You saw the instruction. You get to be the determinant of the time. I would say to you, the first assault on her happens at 6:26 or 6:27 before, in fact, she makes that text. And we know from Dr. Petrangelo that she has bruises under her arms. We have to wonder if he had grabbed her and attempted to move her in, and she got away that first time quickly up the path. But at 6:28 is when she makes that text. And at 6:30, she's in the bushes being murdered. That 3 to 5 minutes, especially after he failed the first time to kidnap her, he formulated a new plan that included the helmet for the assault. That's the time for that premeditation. Now, the second theory is the time theory that we talked about a little bit in jury selection. That instruction shows you that you have a chance to take a look at it and think of it in terms of reflection and second thought. Case law is very clear. Because this is not a gunshot or a knife wound, there is time for reflection, especially in suffocation and strangulation cases where it takes minutes to die. Courts have said we don't have the chance to use as premeditation the time it takes for a person to die, because it gives a chance for the defendant to have second thoughts or reflections on what's happened. Dr. Petrangelo told you that it took her approximately 10 minutes to die. Can you imagine the amount of force necessary to crush a larynx and a skull and a chest because he let her suffocate to death? We know that that video is 14 minutes where he is in that area. And the doctor told you that it takes 10 minutes to die. And we know that she was alive during part of it because of 2 photographs from the crime scene. While she's being stomped to death, she's grabbing the leaves around her. And that, my friends, is a tear in her eye. She's unable to act. That time period is premeditation because he did nothing to stop it when he could have. All right, back to what I was saying before. Why is he at the trail? He's at the trail because of that YouTube search that he did. July 18th, 6 days before the murder. These are the most important ones. I don't need to show you all. We've been doing it for months, as you saw. Most important, why would this girl say, I'm too old for her and still hit on me? Why would this girl say, I'm too old for her and still hit on me? Girls say, I'm too old for her and still hit on me. Do young girls like older men? How to make a girl that does not want you to want you? I guess say, the use of a helmet is a way to get a girl's attention. And the two I didn't put up here, remember? In the same day, he was looking up hypnosis. Hard to hypnotize somebody when you've knocked them out. But we know a couple of things from that day from his phone. We know that he was in Armada, and we know it several ways. First off, we have his phone at 6:39, 5:39, clicking, going along Armada Ridge to the second call at 17:39, and then we come down here to Romeo, well, maybe he went to, I guess, the Tim Hortons, but then we have it coming back. So, first thing we know is at 18:04, at 6:04 p.m., he is in the village of Armada. Now we know from the statements he made to Peckman that he is in, at that time, the village of Armada. We know from the defense presented here at the Marathon gas station, they're saying that's him in the village of Armada. And we know by looking at that video, that motorbike, which he says is him on it, will match the cost one. And we're going to do that in a few minutes because that unique fingerprint, if that's him on that bike there, that's him on the cost video. That's him that did the murder. So, we also know from his phone records at 6:14 and at 6:17, he's making a phone call. All right? We know that the Marathon, this is what the band that Agent Hess put together. We know at the gas station, the Marathon gas station is right there. Armada is that area. He makes two phone calls. You heard from Higgison, the first call was very short, may not have been picked up, but you heard from Higgison, the second call was 142 on his phone, 131 on Donnie's phone. That phone is not a voicemail. He picks it up, and they have a conversation. Well, what's the conversation? Conversation is, hey, I got a gift for you. We know he said that because that's what Donnie said. I got a gift for you. I want to bring it over. What time are you going to be home from work? Well, I don't know. I'm not home yet, but I can let you know. All right, hey, the girls coming? Are they bringing the dope? I want to buy some marijuana. Yeah. The girls will be here. The girls will be here after you get here. So, hey, so I'll let you know when I get home. Yeah, do me a favor. Text me when you get home. Click. Because we know that Donnie's text to him at 6:44 is one word. Home. We know from their defense that he's pulling out of that gas station at about 6:18 p.m. So let's play this. Here's the Marathon station, 6:16. You can just let it run at its regular time. In a few seconds, you will see a couple of bodies. The two ladies that ride by here eventually, those are Amy and Gail Spinella. But again, Armada, now it's at 6:17. Here goes the motorcycle. Stop it right there for a second. No, wrong button. Let's get a little bit ahead. I want to show you some of the specifics about this motorcycle. Here we go. First of all, you can see the big helmet right there. See the lights right there. He puts down white tennis shoes. White tennis shoes. Now watch. We're going to stop it right in this frame right here. Remember, you can't go left there. Bang, stop it. There's that white fender that we've seen. There's the non-existent fender, which is that black fender. And there's that helmet. We will show that in a different blow-up later on. But that photograph is clear. That's the same bike that we see in the other one. Now, he goes down that way, and he comes back around. We don't need to play that. But then he goes down Church Street. Let's go to the next one. Obviously, his brother's not home. He has time to waste, I guess, as opposed to using the more graphic term. So he comes off of that and he goes down Church Street. Now we know that he knows that East Main Street or Armada Ridge goes to his brother's house because he's been down it already. There is no reason to go down Church Street unless you're going to the trail. And we know at 6:18 or 6:19 he comes around and he's going down Church Street, and at 6:25, 6:26 by the Reschkes, by the Spinellas, by the Signs, by Mr. Buchanan, he's seen on the path. He didn't leave town by turning onto Fulton Street, and we know that for two reasons, because he's seen on the path over here before the murder, and we know that Detective MacArthur watched hours of security video from this business and this business as to Fulton Road, and there were never any videos of that motorcycle or any motorcycle going by at that time. So, regardless, he's over here. What I said before, when you get into this maze here, coming off as he did onto Church Street after the murder, there are two ways to get to North Main. You could take any one of these streets or any one of these cuts and not make it. Only somebody who knew that neighborhood would know to come up, go down, come down here, come down, come around, and go specifically on Madison Street to get to East Main. Only somebody who lived in that neighborhood, knows that street, would be able to do that. So we know that he is, in fact, on the path at that time. I want to debunk a couple of myths about this case. First of all, I guess, who does Mr. VanCallis think he is, like Al Capone or John Gotti or El Chapo? That we did a backwards investigation, that we decided when we found April Millsap's body that we're going to simply pin it on him? That for some, Chief Smith has been there for 8.5 years, had never heard of the name James VanCallis, didn't know who he is. We worked backwards. We decided to find a pair of shoes, match those shoes, know that he had a pair of those shoes, and then match those shoes to him, find somebody in the area who owns a motorcycle, and say, hey, he's got a motorcycle. Let's pin it on him. Really? Really? What is all this? 1,000 tips. 1,000 tips. 75 investigators working full-time for weeks to find 1,000 tips. Each tip was looked at. Each tip was investigated. Each tip on here has a conclusion indicating what was done, where it was done, and how it was closed out. How about the fact that Armada Village is small, so that they went to every house and every business in Armada Village and asked questions and filled out surveys, getting information. What about a rolling stop or a roadblock where they stop hundreds and hundreds of people? There may have been tips coming in on James VanCallis at the time, and those were sent to a special unit. But they didn't avoid any other tip. They didn't stop looking. They spent months investigating every possible clue to be certain that there were no mistakes. And is there a lack of physical evidence in this case? Remember what Kozlowski said. Absence of evidence does not mean evidence of absence. And that's pretty damn certain when in fact you've destroyed all of the evidence. When you come home after stomping some young girl to death with your shoes that are this size that have this type of cleat, and then clean it with hand sanitizer, and then put them in a box and get rid of the box. What about the helmet? You saw the helmet. You saw the photograph of this helmet. You saw how messy that house was. OCD my ass. Okay? The only clean thing in that house was this helmet. And you saw all the streaks on it. Because he cleaned off the DNA. Cleaned off April. In fact, he did such a nice job, even his DNA wasn't on the helmet. And then he takes his Carhartt hoodie, something that would have had blood spatter on it from moving her body, and he throws it out. And then you take the pants, and you wash the pants, and you get rid of those. And then you take the clump of hair that could have been April's hair, and you take that off the sink, and you throw it out. Yes. There is no physical evidence, but it certainly wasn't for lack of trying. We can't get to what he's already thrown out before we know it's him. So yes. And at the same point, what is this? There's no DNA. There can't be a case. Science is used to enhance police work, not replace it. I'm sorry, was there a criminal justice system before the 1990s when science came about? Were there not convictions in the 20s, 30s, 40s, and 50s when there was nothing but circumstantial evidence? We don't even know how the pyramids were made. We don't even know why Stonehenge exists. But we know the law allows us to present circumstantial evidence in this case. But I will tell you something about DNA and physical evidence. You heard from the experts from the Michigan State Police that in fact, at the vast majority of crime scenes, no evidence is left. And you want real-life examples of that? How about the fact that we've got that helmet? And that helmet is worn every day, and I'll bet all VanCallis did was clean off the top of it. He didn't clean off the interior. And he wears that helmet on and off, day after day after day. The best that we could do with DNA is simply not exclude him from that helmet. What about the hand sanitizer? Something he's supposed to use every day, and Crystal uses every day. His DNA is not on it. Her DNA is not on it. No fingerprints are on it. Same with the Windex bottle. Something he uses every day. He doesn't leave any DNA. He doesn't leave any prints on it. Same with April's phone. We have a smudged print, no DNA, nothing. Yet it's something she uses every day. Proof, what the experts are saying. Just because you touch something, because you handle something, because you have something, you don't leave a trace. I wish we would have been able to get something off the foot pegs on his motorcycle. Either it didn't happen or he cleaned it. But there was DNA in two spots. There should never have been DNA on a 14-year-old girl. There was DNA, male DNA on her shorts, and male DNA on her tank top. It may not have been enough to give us a sample, as you heard Andrea Young talk about. She did the YSTR. There's a Y chromosome there. It's male. Just not enough to give us an identification. So there was some physical evidence. So what am I supposed to do? Not bring a case? No DNA? We just let people go? There's a bumper sticker that I see on trucks all the time. It says, red, white, and blue. These colors don't run. Well, neither do we. This is a strong, significant, circumstantial case with a tremendous amount of evidence that says Mr. James VanCallis is the murderer of April Millsap. Now let's look at a timeline. Mr. Land's testimony is very important for one particular reason. Mr. Land comes through at 6:47 by the granary. Zent's graphic display on her phone has that motorcycle as VanCallis crossing onto Depot Street and onto Church Street at approximately also 6:47. He did not see a motorcycle. That's how close, within seconds of them passing one another on the trail. We know that Amy Spinella makes her identification at about at some point, but at the same spot. Sedais make the 911 call at 8:19. The Steins, according to theirs, see her at 6:26, just on the edge of coming up towards the Orchard Trail. That's almost the exact same spot on the GPS of April's text, which is at 6:28 p.m. So right here, remember the Orchard Trail is right here. Her body is right here. The rescues say, again, she's walking back toward them as they're going east, right about here. The Spinellas say they encountered the motorcycle right about here. And we know that by her own tracker at 6:23, she has hit this clearing and she has turned around to go back in. 6:24, Mr. Buchanan comes by, and right at that edge, that's where he sees VanCallis. Next. These are those photographs we talked about. The murder spot is right here, this little dirt spot. This is the Liberty Trail. So let's a little bit past the dirt spots right here. We'll see it in just a second. But this photograph was taken looking down from Liberty Trail to there. This photograph was taken at the murder spot looking down, heading east. Just so that you get an idea when we're talking about the isolation, when we talk about after the assault, he's looking both ways. The He knows he's got limited vision and limited time to do what he needs to do. But that's a spot where it's clear that on that whole path that's on that curve, a slightly greater limited eyesight area. Before we start talking about the eyewitness identification, which is a big part of our case, I want you to see the instruction that you're going to be handed in your path. How good a chance the witness had to see the offender at the time. How long the witness was watching. Whether the witness had seen or known the offender before, which in fact, other than the Reschke's seeing April, how far away the witness was, whether the area was well lighted, and what was the witness's state of mind at the time. That becomes important for both Buchanan and Stein. Also, Amy Spinella. Also think about the circumstances at the time of the identification. How much time had passed? How sure the witness was of the identification? State of mind during the identification. And then you also may consider times when witness failed to identify, make an identification, give a description that didn't agree with the description during trial. The next photograph is very pertinent to the difference between the Steins and Spinellas. Stein and Buchanan and Spinella. Like the bumper sticker says, do I have a discrepancy? Yes. But I ain't running from it. I'm admitting it, and I'm going to explain to you why it's in fact not really much of a discrepancy when you analyze the facts that went into both identifications and understand the context of both identifications. So for this purpose right now, you see that this is just a sample of what the Buchanans and the Steins are doing as they're coming up. You can see that there are no distractions to what they're looking at as they move through and up and upon somebody. Where when Miss Spinella goes past, you have not only distance, you have foliage, and we'll talk about the fear in just a second. But I think Amy Spinella should be given some credit in her testimony here. There's an old Indian proverb that says, once you come to a fork in the road, you can take either the path of conscience or the path of convenience. She came to this court and she took the path of conscience. How easy would it have been for her to just simply say, because there's no way anybody could have done anything different, say, well, my composite wasn't as nice or wasn't as good, or maybe I made a mistake in the composite, but that's the person I saw on the path. She didn't do that. She took the path of conscience. She wouldn't say it was him, but she couldn't say it wasn't him. And what we're left with in her testimony is essentially her composite. And I'm going to put that composite up. And we're going to compare that composite to a couple of photographs. And I think you're going to see by the time it's all done, what you heard is in fact not that good. What you're going to see is in fact that composite's a lot stronger than you were led to believe. But let's go first to the Stein and the Buchanan identification. The factors that are important in their identification. The first factor I don't know much about computers, but somebody did this for us. Distance. I'm going to show you the motorcycle photo video again in a few minutes with Sandra on it that was taken at the house. So you can see just how far away you could actually see that light so that you know what Buchanan was talking about. But if you picture yourself on a bike on that path, what you have is as you're coming up, even though you might be at 12, 14 miles an hour, you're going from far to near. You're coming up on that person. Those individuals, there was nothing in between them and the person that they saw. And again, give Doug Stein credit. Doug Stein could have come up here and said, hey, yeah, I was with Mary and I dipped in behind, but I saw him, but he didn't do that. These are not people that wanted to be involved in this case. These are not people. Do I bring up the issue of education? Yes, because Buchanan and Stein are educated. But is it simply because of education that I bring them up? No, what it does is, as Mary Stein said, it helps to articulate more effectively what they saw. They're not gang members. They're not street thugs. They're not involved. They're not victims. They're just simply saying, this is what I saw. I happen to be at this place at that time. But because of their articulation, their ability to think back, and their lack of wanting to see something happen other than this is what I saw, that's what the education means. It means the ability to simply to come here and do what's right. Certainly not because they want to with all these cameras in their faces and everything else that goes with this case. Next. Time. The time will vary, but the distance on the bike, regardless, is that time it takes to get from here to there or there and beyond. But that whole time they're looking at one thing, that person. 3. What makes this, their identifications, more understandable and accurate is they were not happy. None of them had ever seen a motorcycle on the path before, and they didn't like it. That path is for pedestrians and bikes, and now there's a motorcycle on it, some punk on a motorcycle. So now they have to look at it and calculate the next move. Is that guy going to come across? Is he going to stay on the right-hand side? What's he going to do as I approach? So, of course, now they're actually really focused on him because they have to figure out whether they're going to move, whether they're going to go left or whether they're going to go right, which is even more of a reason to be staring right at that person. 4. There were no distractions. You can see the lighting. It's still the middle of the day. It's still bright. There's nothing between all of those witnesses and the motorcycle as they came upon it. Nothing. And 5, they pass within feet as they're on that path, which is only, as you can see, about this wide, and they're elbow to elbow, as Mary said, this close, the ability to stare right at you as they come by and move past. And 6, 10 out of 10. The certainty was 10 out of 10. Now, Mary Stein's situation. She was, at some level, dissatisfied having spoken to her cousin, thinking that there was going to be a lineup so she could come in and do a lineup. She was told she'd have a role in the composite, told that she could look at the composite first. But it didn't happen. The composite was released. What's the first thing that she does when that composite is released? She calls Donahue, the officer who came and spoke to her, and said, I saw the composite. There's a couple problems with it. The hair's not right. He looks too young. That's not who I saw. Immediately after, not waiting, not looking ahead, immediately after she makes that complaint. But there's nothing that can be done. As you heard from Becky McCarthy, they're only going to do one composite. They only had one composite artist. You can't have one composite artist do 2 different people on the same case. Did she go online after the arrest? Yes. But you have to then judge her credibility. Do you believe that she just simply went online and said, hey, that person's arrested, that's who I saw, that's who I'm going to say was it? She is so nervous and concerned about being right, and so pained about knowing how important what she saw is to the Millsap family, to the Armada community, to everybody, that she wants to be certain. Immediately upon seeing him arrested, then she goes on the internet and she says, yes, that's him. And then you have Bill Buchanan. If there is an organization called Engineers Anonymous, I will join. Because I have been rehabilitated. Geez, was I wrong about engineers? I came to maybe have a change of heart because he was so clear and so unflappable in both his testimony here and in what happened during that test as to what he saw, why he saw it, and how clear he was about what he saw. because Mr. VanCallis gave us a picture of himself from his phone, taken from an elevated position that shows, oh, what's that? It's a mustache. One that he wouldn't let be seen during this fake example, as Mr. Buchanan was trying to say. The lights are wrong, the path is wrong, there's no speed, the height is wrong, everything was wrong about that. But it really didn't matter because in a picture he took of himself, you see his mustache. Moving on. These are some generalities. I've talked a little bit about most of them, but I love lists. And I wanted you to see the lists of what people said during this trial. All of the eyewitnesses, 2 of 1, indicated they thought that they were together. They were boyfriend and girlfriend, stepfather or older boyfriend. But something was wrong. They all said something was wrong. It looked like they'd had a fight. She looked tense. She had a tight smile. They were close together, then she turned and walked away from him. And April was always looking down at her phone. The description of VanCallis was pretty much consistent. Everybody said the same thing. He was not dressed appropriately for the path. He was not in exercise clothing. And he was not dressed in clothing that was appropriate for the weather. He was not friendly. That he ignored everybody. Camel pants become really important because he indicates that he's wearing camel pants. Crystal indicates that he's wearing camel pants. And Mary Stein, in her first statement to the officers, that one that she wrote out, indicated that she thought he was wearing camel pants. She got here to court, she said it could have been camel, it could have been long, dark pants. But her first, within a day, was camel pants. They all basically indicated he had long, dark pants at some level and a shirt. They all said they could not see any skin showing. High-top tennis shoes are very important in this case. Because as you recall, the K-Swiss, especially the black and white ones, which become the focus of our case now, are in fact high tops. And they're very white, which is why you can see them in those motorcycle shots. And Gail Spinella told you that the person was wearing high-top tennis shoes. You've seen the photographs. I'm going to show you more in a second. The K-Swiss shoes are in evidence. They are not high-top tennis shoes. And everybody saw that full black face helmet. Descriptions of the motorcycle become very consistent. No one had ever seen one on the path before. They all agreed it was an enduro-type bike, an off-road motorcycle. Reschke had the colors as blue and white. Gail Spinella had it black, blue, and chrome, which could be mistaken for white. But again, the key factor is the blue and the light colored, and we all know that black fender. Crystal said he was that motorcycle, which we know is blue, black, and white. And in fact, the defendant said he was on this motorcycle that day, which we know is blue, black, and white. The motorcycle was not loud. We'll play that for you again at a more reasonable level to show you, in fact, that motorcycle was not that loud. So Reschke is correct. Buchanan is correct. Four-cycle, very smooth, soft, not like those Harleys that you hear going up and down your street that you can hear for a half mile away. Everybody was certain. Male rider was male, not female, younger, tall, and at some level thin, whether you want to say 180 pounds at 6'1" or 200 pounds at 6'1". On that frame, you've seen him stand up a number of times. That's the frame. Let's talk a little bit about what Amy Spinella saw. First of all, you have to incorporate the fact that she too is going about 10 or 12 miles an hour. But instead of coming head on and staring at somebody, she is just simply riding on a bike, hears a dog, and looks to the right, which is this. What she sees strikes fear into her, which is why she told her mom, Gail, we got to get going, don't stop, we're going home. Because whatever she saw, whatever innate emotion she felt, It was a base instinct of fear. The distance was far greater because on the path they passed within feet of one another. This is clearly going to be at a minimum of 4 or 5 feet in there and then 15 to 20 feet in. You've got the foliage right here. Yeah, there are some open spots, but there is something directly in the way. But all 3 of them were clear on one thing, and that is the eyes. They all saw the eyes. Buchanan, Mary Stein, and Amy Spinella were locked on those eyes as you've been locked on for the last 2 weeks. And it was the start of movements as part of that fear. So let's show you those composites. This is just simply a straight up shot right off of the composite. That's Amy Spinella's composite from 7/26, which would have been Saturday, and that's Mr. VanCallis' booking photo when he was arrested on 7/30 of 2014. We've isolated the eyes. The eyes match. As clear as the witnesses told you, those eyes match. Now let's cut off the hair a little bit. Sides here look pretty consistent. Eyes we already know. Take a look at the ears. Ears are a perfect match. Take a look at the lips. The lips are a perfect match. Take a look at what I had to ask my wife last night what this was. That's a philtrum. Matches. Prominent. Take a look at the space down here in the nose and the width up here. Matches. Look at the shape of the face. How it comes down. Matches. The hair doesn't. There's no facial hair. That composite is not as far off as you would be led to believe. One of our other main witnesses is Crystal Stadler. I think it would have been real easy for Crystal to come in here and just simply say more than she did. She could have come in here and said, he confessed to me. She could have come in here and said, before he got rid of the shoes, I saw blood. She could have come in here and said a lot of different things. She didn't. It's not her place. If anybody knows what it's like to be in the situation that she was in, it's those who have had or have been themselves victims of domestic violence. Crystal Stadler is a victim of domestic violence. His behavior was physically and verbally abusive, she told you, and controlling. She exhibits all the signs of a battered wife. But she's submissive. She's not vengeful. She had no attitude. She didn't come in here yelling and screaming and whining upon the flesh. Was she easily confused? Unfortunately, she was. But I don't certainly think that meant she was lying, or that she fully understood the gravity of everything that was going on. Next. Think about it. These are the living arrangements. They're living in the mother-in-law's quarters in that place. No driver's license, no car, no phone, no computer, no friends, no job, no authority around the house, and she's got 2 small children. Next. Think about it. This home life is like an episode from Jerry Springer. I agree with Mr. Sheep. No electricity in their portion until it's turned on by the generator. No water unless they turn the generator on. You saw the buckets of water that have to be used for the toilet. Can't use the toilet anytime you want unless there's water there already. No dryer. She's not allowed to use the dryer. Heaven forbid, that would take too much power, because her section of the house is not on the grid. Brenda's section of the house is on the grid. And she has to ask permission to either have the power turned on. There are specific times that she has to use the appliances, because that's controlled also. She's got kids in the yard, 4 and 5 dogs. You see garbage strewn all over the place. And the living arrangement of James VanCallis' mother with a new husband in one part of the house, her with James and 2 kids in another part of the house, and his father living in separate quarters in the house. Next. She did the best she could. She told you the truth and she remembered it. And this is where your role becomes very important in these cases, because you're the one that judges the credibility. By Mr. She coming up and beating her up and making her confused, does that make her less than she was? Or was she just too complacent when I was asking her questions? You have to make the decision. But I would tell you, based on what you saw and what she said, she was as straightforward as a person that there is. She was the one that clearly showed us his favorite shoes are those black and white Nike Jordan Flight Power. And what's nice about that is you don't have to take just her word for it, because there was no proof anywhere that these shoes were at her house. Okay? In fact, the defendant's photographs and videos of himself wearing those shoes confirm that those were his favorite shoes, because he wore them and videotaped them all the time. He wore those shoes on July 24th, 2014. You can tell that by the pictures on the motorcycle, Crystal's testimony, and the tread pattern on the back that matches the tread pattern of the stomping that killed April Millsap. That she indicates that he wore camel pants that day, had a sports t-shirt and that Carhartt hoodie. Now, the nice thing, if you remember that Carhartt hoodie that we saw in the photograph, and any of you that have either owned a Carhartt or seen a Carhartt or had any type of clothing that had writing on the outside, you know that it's that neoprene rubber stuff, that very reflective stuff. And Carhartts have it on those hoodies. We showed it to you. Big old white letters, Carhartt, all the way down. That is critical in all the photographs we're going to look at in a second of the motorcycle, because you can see that Carhartt jacket in every one of those photographs, that Carhartt writing. She told you critically those black and white shoes disappeared the next day with a box, because in fact, when the officers did that search on the 30th, there was no pair of shoes. They were Nike Jordans, gone. They were K-Swiss, of course. She found it odd that he was cleaning his shoes at 2 o'clock in the morning with hand sanitizer. She'd never seen him in the 8.5 years they were together cleaning shoes before. Never saw him clean a helmet. He claimed that it was oil. And, I mean, in all honesty, if you took a look at that driveway, which we showed you, if there was oil on it, it had to have been months and months and months ago, because as of that day, there was no oil, no dog crap on that driveway. Clean. And any of us that have worked in cars that spilled oil, you've been at the gas station when somebody spilled gas in front of you, and they put that gravel stuff down, that stain still stays for an extended period of time. On the 6th day after that murder, there was no way, if there had been any of that, it would have been cleaned up by the time those photographs were taken. His order to her to wash the clothes on that Friday. That clump of hair that she found in the Carhartt hoodie, that because she is who she is too afraid to say anything to him, and just leaves it where he can see it to let him know that she found it. Carhartt hoodie disappears, we know that. Threats by him the day before she left that if he got arrested, she would be arrested too. And if you understand the battered spouse, she doesn't ask why, or she doesn't push back. Why? Because it's not her place in that relationship. I think it's real important that we summarize the VanCallis statements. Critical. I messed up. You need to stand by me. As a batterer, he's not about to tell her the reason why. She doesn't need to know the reason why. You do what I tell you. So I'm going to stop. I'm not telling you why. And you're going to need to stand behind me. She doesn't question it. She's afraid of him. Then he tells her to lie. I was wearing the K-Swiss shoes. He makes to called him the second day on Saturday, say, can you come in and make a statement? He started screaming at him. This is a witch hunt! I'm not doing it! I'm not doing it! Really easy to scream at somebody when you're not face to face or you're a woman. He's real brave on the phone. He's real brave with a 14-year-old girl. Then to Donnie VanCallis, another request for a lie. Erase our. Leave it right there for just a second. All right. This is the photo that night. See it now, it's more. Photographs. Now we can see what we didn't see. All the clean streaks. Look how beat up those shoes are. Now let's go to the next photograph. Let's look at all the photographs we have. Way to clean, nice. One part is the number of times we showed you these shoes, just to validate how recently he had them. That's in the summer of 2013. That's November of 2013. That's December of 2013. April. No, this is December. April, and the this one is this pattern is shown very specifically. That was in April. This one, though, just a flash, was June 18th. So as of June 18th, 2014, he still had these shoes, and they were in really good shape. But it's like exhibit pulled that shoe off of. A video where he's sitting in a car. We're not here in a parking lot in the car next to you. Well, take that down for just a second. So look at the information we got about from his phone. We're going to show you the before and after photos. The modification of his motorcycle, which is motorcycle unique, came from all of his cameras in his phone. The photos and videos is not the video of how quiet the motorcycle is came from the photo of red tinted hair. I don't want to hear questions about red tinted hair. On his phone, he took a red the photo of him wearing that mustache visible in his phone. The times and locations of his phone before the murder of his phone. That critical text message came from his phone, and that video came from his phone. Sandra, his sister, on the motorcycle. A couple couple interesting things about it.
Yeah, because wipeouts are always like
What's your question now? Don't get in your man's way.
How clear that light is. Now, Mr. Buchanan, that light from extended distance on a video from his own phone. That's how farther back would be my.
Yeah, right?
Else in that video? You notice what you have here? That camera passes. That's how fast they used to know how to pass. He was in there. Did you look for that? Did you see it? Or you got to go back and stop? The situation she faced. That fast. The phone demonstration that was done on a motorcycle. There was this issue that Buchanan was talking about him being up and the motorcycle being lower. And then Mr. Sheet talking about, well, when there's weight on the motorcycle, that's why James VanCallis trying to get a little bit of our own stilling here, okay? Here's a photograph of that bike as it sits without any weight on it. You can see where that cowling is. And now you can see where it is when there's somebody on it. So again, go ahead and put the rest angle. There's no doubt. And if you take the red line, if you could. This is not a red line. Everybody thinks hard anything else. When you see it, it's not that large. Everybody says it's an enduro or a moped or an off-road bike. There it is. And with that means he's not going to you can't stop that bike. Once again, can see a mustache. Hold on just a second. Go to the motor comparisons. There's a photograph of what that bike looked when he, and let's just confirm the modifications. This went from white to a gray, like a Bondo. The white gear, this is critical to everyone. These two items. Number one, which is white and broken up by the poles of light. And then this other fender, and that's why that disappears in almost every one of those photos. Very few different colors. You've got blue here, which is the only blue left on the bike. That's why it's so important. The Rush, Gail Stein, prominent is right there. In the videos, again, you got this is it disappears. It comes white and it becomes black, and it has then this is what makes this bike unique. This is what makes this bike unique. He made these changes, and these changes are visible. They're not standard changes. You have these exhibits. why this just simply. But what you can see here, like high top tension. That. Some of the images that we put them on one. The back cam, Mr. Cross's house, and then this. What's critical about this? You've got the white here, the white here. You've got the black here, black fender raised like that. The most important part of this motorcycle is different. That's his motorcycle. What do you see here? Two different size tires. Okay. Now, this is the station one right here. This is the cost one. This is the bike itself. Again, it's the white back, big the bar right here, right here. At Marathon Station. That's him on his bike at Marathon gas station. And cost. Which photo? Okay. Petrangelo. Look, Bruce, above his eye. Said that was consistent with she said force that Bruce was out for you. Here's lines up. I need you to ask the cameras not to show.
Media is instructed not to take any pictures, photographs that will be filmed. You're going to be contempt proceedings.
There's one and only reason you he has no reason to embarrass her. He has no personal connection with her. Strangers. This case was a essentially, did we spell out larceny? Okay, we did spell out kidnapping. Go to kidnapping first. Really, you can read the instruction. That's what I don't know if there's any reason to leave her. Going to rape her. Another person that you intend to engage in information. If there was any reason to move her out and put her in that kidnapping, read the instructions. All he has to do is move her. Larceny. All we would show she died during the course of his. We know he left her backpack and her phone, dogs, and the dog's car. That's you'll see. You have to leave the premises. You can get out of Home Depot if you would do it at the time. This was completed. I think we're there were 5 categories. Five. That's where Mr. Sheet got his percent. Remember when Mr. Daly questioned, there were 8 categories total. And then you have levels 1, 2, 3, 4, and 5. You also have a category on student. You have a category on elimination. You have a category that includes we use the engineers. This of 8. To take these back and look at the bottom, compare with all the we're introduced. Here, and then you will see where take a look. Do your own. Watch this.
Take to see you back here at 10:50. If you want to leave, you can. I have no objection to that. Talk 10 minutes, any conversation if you do, and I would suggest the deputy if you need to have a garage and let them do it there. Thank you. So if you need to use, you want to go down to the cafeteria, we'll escort you down there, and as well as if you need to go outside, we'll take you out that to the back way, okay? Thank you.
Thanks, sorry about that. You're good. Fine.
I'm like this.
Yes, sure.
Okay, Mr. Sheik, you may begin.
Good morning, ladies and gentlemen of the jury. Thank you so much for listening to everything. We know it's been a hard case and it's been a long case. And no matter what your decision, we want to thank you for taking the time to listen to everything as attentively as you have. When you get up here, this is always the hardest part of the defense attorney's job, is because part of you wants to get up here and outline everything and go through everything A through Z, and part of you realizes that the jury's probably sick and tired of hearing the same thing over and over, and would rather you get to the differences between yourself and the prosecution. And that's what I'm going to attempt to do. We've pretty much heard the story. You've heard Mr. Cacallo indicate very productively that this was a brutal crime and that the person that committed it should be punished. And that's always been our position as well. Big difference, obviously, is that trying to leave this to Mr. VanCallis to the point where 12 of you could go back there and unanimously conclude beyond a reasonable doubt that he's the person that committed this crime. So what I'm going to do is I'm going to start by witnesses, what they said, much in order of what I think. One of the most important things you want to consider about anybody's testimony or anybody's going to life is all pretty consistent, but there's vested interest in it, and it doesn't make common sense or not. And if you kind of know those three things, it's not like a fact, but at least it's a gauge that you could use to try to assess the weight that you want to put on testimony, especially when you don't. Let's start with the first witness we have. First witness, let's actually bring up all of her. The first witness, the agent. He indicated that he worked years with the FBI, and that he had done this animation to create the first kind of information. He created some form of application to others, information for Finland, as to how to use it. He downloaded something. I asked him about why. He said that he had not studies. I also believe asked him if that reflected that, and I think he said it had not. Talking about first methods, this is something that's you look at that application, and you ask me, when you look at it, and it's about 17 the trail. She's the trail forward. Here is that Mr. VanCallis, and you're up on gas, goes there, makes a 1 minute or 2 call to his brother Donnie, talks on the phone to him, and then after that he leaves. He goes left, and then he goes that way, and then south. Here he is. April, and he decides to follow her. That's 4 there's no possible way that he could see that where he's going to church is totally that he, you know, the argument all sorts of things as we have sidewalk. I remember one thing. I remember all these seasoned officers, and everyone talked about the message. Had a hard time going west. But I can never remember. North is always up, south, east, west. And they were having such a indicating that yes, he's going in that direction. They went south, which as you know from testimony, which has been consistent, also leads to the Tin Courtrooms. So that's where that's concerned. You cannot even see it in the middle of the trail. If they're fit, you'll see that on there. That's as far as Agent Stent's testimony. He gave very professional, everything that he could, for whatever animation he created, I mean, are his creations. As I asked him repeatedly in the answer, these were creations, not simply download capture or something like that. He's the gentleman that saw the motorcycle as he had heard of a bull, look out for the media and he happened to drive. Picture. He did not take the license for handle grips or anything like that at that time because I think he thought that that was going to be important in the case. As it turns out, the next day we find out that when he goes and talks to news told him very honestly, he belongs to a friend of mine, James VanCallis, who's over here all the time, hangs out, and that's when they're Mr. VanCallis. If you remember, Trooper Packman indicated when he went there was a female who was out initially, and then I asked Mr. Stabler, corrected him, and Mr. VanCallis showed you football or sorry, not football, the motorcycle and everything else that was going. He's asking him if you want to take anything, take with yourself, take some things, take pictures of yourself. And they did. But the important thing is that Crystal is supporting to Trooper Packman when all this information is given and you can give it of Mr. VanCallis that day. Back about 5, again at 5:30. I said, John, that we came in and I was asking, Cataldo was asking, hear that, yes, I'll find it there. We looked at an answer to the FBI that was very honest. No matter what anybody tells you, one of the most important things I got to mention at the beginning, Judge Sarnowski's going to be very important under the law. Opening statements arguments are not evidence. It's just whatever we talk. Even if we ask questions, it's not evidence. It's answer that. So everything Mr. Cataldo got whatever I tell you, you don't have to take my interpretation. Just follow up on the okay? In that sense, Crystal's right there. We'll get back to her. Statement cost, the video is absolutely indicated the FBI. Two cameras, you have a video from there that shows you the brief time that a bike goes by. The position is next officers that had come in this case. They knew that there was a different pickup. He knew that that was he couldn't say how much if any of those had to do with Mr. VanCallis. We got to that later with Detective Sergeant MacArthur. Not flagged out that number 42 had to do with Mr. VanCallis, and that's how we got it. Also, text not tied in directly. It speaks a lot. Now, when we talked about the looking at the debris and he was short. said is 7 Street, and he tried to explain at the 8 feet that in that split second he could identify Mr. VanCallis. That's why we had him put the helmet on and indicate that you can't see any facial hair. When I asked him about facial hair, remember he said he had what I thought was the unusual response about eyebrows. Most people don't consider eyebrows and eyelashes as facial hair. I suppose technically, but in everyday talking, people talk about the beard and the face. Now, when you can go back and look at that picture, look it up and say, well, it must really look hard for it. You're looking at it blown out in front of you. The prosecution has, that's the one that they thought was most persuasive. Look at it. Even then you have to strain to see if you see any hair. You can't. So Mr. Buchanan's identification with April Millsap is suspect in that, because first going at average speed of 17 miles an hour, even if you were at half speed at that time, and you just happen to go by somebody at 6 to 8 feet, somebody you don't know, how much of a glance are you going to get to look at them when they were in the helmet with the shade on? Then he kept saying he was 10 out of 10. Nothing was going to shake him, you know? And that's a little bit. Think about it. How much are you folks certain about 10 out of 10? I'm not saying that he has. He, like the other witnesses in the case, admitted to you, Mr. VanCallis, and that's what fine-tuned their identification of the person was who was. Witnesses, including Mr. Buchanan, TV and so forth. Now, let's talk about that. Normally what happens, the purpose of a raid or any kind of police action, usually or military action, is the element of surprise. Tomorrow at 2 o'clock and look for the cookies that you have. You show up there and then you look for what you want to look for. So why was this raid so well and remember or not, possible picture of him is put up all over. That's a little disingenuous. If anything, I think that led to more problems because suspected and we're going out there because they got more marijuana than they should. The second Pablo. And after that, people start changing the vision of what they think it is. Mr. Buchanan indicated another person. That's him. I know it. I saw everything else. So I'm not going to leave you at that point, but go back and look at that and he did that's fine. And he indicated that. Then we had the Spinellas. We had Amy Spinella, which is your daughter. She came in and she indicated that she's going by the bike. She doesn't wear glasses. She wasn't wearing sunglasses. She was riding her bike. You know she was emotional because I think the prosecutor, somebody actually had given her some Kleenex. She was very sad about what happened, you know. She's pretty certain that that was April that she saw on that day, at that time, on the trail. She told you it's not Mr. VanCallis. If you think back about her testimony, if you took any notes, she would say, she didn't just say it didn't look like him or doesn't. She said, no, that's not him. That's my recollection. Go back and look at your notes. She was much more adamant than, oh, I'm not kind of sure. It could be, it could not be. She said that's not him. If you remember. And that's one of the best witnesses. That's one of the witnesses that, with all due respect, she probably wasn't riding the bike as fast as Mr. Buchanan or perhaps Miss Stein. But when she's going by, nice and slow with her mom on a leisurely bike ride, she's going to get a very good view. Some twice, as you also understand, they were also at the Marathon gas station. If she thought that was VanCallis, she saw that's the guy just saw at the gas station come in and testify. She told you straight out, despite her really wanting to help. It was her mother, Gail, she couldn't identify him. A younger person. The deposit was made from another person, corporation, anything like that. She indicated to you, so over an hour, the state police kept asking, do you want to change this? Do you want to change anything? About it, do it. And clearly that person didn't look like that. That's what this she came in here and she testified that right by spot. And everything. So that's a little suspect. I mean, people do things differently. But that's what she did. And then she says that she did finally contact Donahue, and she was told something like, in an investigation where we have the FBI involved, we have the state police involved, we have the Oakland County Sheriff's involved, we have Armada police involved, we have drones involved, we have people contacting software manufacturers in Finland involved. We have practically every kind of science that you could think of, cell phone technologists, everybody involved in this case. Are you going to try to tell me that somebody's going to say, oh, I'm sorry, we only have one piece of paper, we can only do one composite, we're not going to redo it, or we're not going to adjust it? That she had called and been adamant and indicated that that's different? You know, that's something to think about. Now, on top of that, she also indicated that she followed the case online, she followed it on TV, she followed it pretty much every form of media that at least I enumerated before her. She said, yes, I followed it, called the police several times. She was a little bit hesitant to tell us exactly how many times, but many times. She called the Crime Stopper line, she called, I think, Detective Donahue, and other people like that. She said somebody that wants to be a little bit involved, maybe she feels bad because she doesn't have pertinent information to help. You know, I mean, that's what I would like to think is a natural thing. And then so when she sees this on TV, she says, well, I'll help because that's, you know, any way that I can help. I could have, I should have done more. Just like this Spinelli's indicated. Should have went back, we could have went back, he thought about it, and you know, and didn't. So it's very natural. It doesn't mean that because people make mistakes in their recollection of what they saw, that they're now figuring this is some evil notion on their part. It can come out of very, very idealistic emotions, and that may be the case here. But you have to look at how important this is in this particular case. If you remember when we had you, when we were first picking you folks, we had you answer 17-page, I think, questionnaire, jury questionnaire. There's a lot of questions on there about eyewitnesses and other things, tons of things. But if you remember, we had two potential jurors sitting here. One who was in the academy with Detective Sergeant McCarthy, and another gentleman here who went to cell phone school and everything. I forgot where he was a police officer from. But both of them had indicated, without any argument or anything in this case, knowing who would be or would not be for eyewitnesses, that they felt that eyewitness testimony was suspect, but they did not, you know, trust it as much as some of the other testimony. And that's what they had sent it out. Remember, we asked them about that. So that's really important. When you have a trooper that's been with the department many years, and you have the other officer, and that's the first thing that they think of is that, well, because they've seen this themselves. And in this particular case, it's very easy for the prosecution to come up and say, we have a case where we have eyewitnesses that identify this person, but that, you know, they don't mention the goatee, they don't mention the mustache, they say the person's older, the hairstyle looked like a perm in the composite, but the length is different, the height, I mean, and the weight, because they're all saying 5'8", 5'10". Consistently, they're all saying teenager, 5'8", 5'10", and the weight around 180 pounds. As we know, when Mr. VanCallis was arrested, he weighed 205 pounds and is 6'1". You know, so I mean, it's more than just a little tiny bit of difference there. Now, we get to Mr. Dutchstein. He's another person that's an engineer, a very nice guy, came in here. He's very honest, and I couldn't find who the gentleman is, so I didn't get a look. But you know, he did get a look at the bike. If you remember, motorcycle. He went home, and he on his own volition went on the computer, and if you remember, I asked him, were you pressed for time? I think I asked him, was this on your own volition, or did somebody ask you to? But regardless, he sat down at his home computer and looked for motorcycles that looked like it, under no pressure to do it quickly or to even do it at all. And then if you remember, he came up with a picture, And that picture is in evidence. I would ask you to look at it when the time comes. That picture does not look like Mr. VanCallis' motorcycle. It has a little resemblance, and then the color's been blue and white. The tires are different, the fenders are different, the height is different. There's many, many, many differences. And I don't think even Mr. Cataldo is going to dispute that. Because I asked Mr. Stein, and all of a sudden they say, well, I wasn't really trying to show the colors, I wasn't really trying to show, because he wants to help too. What does he say? I want to show the size. Well, do we really need somebody to spend an hour, especially an engineer, on the phone looking to see, on the computer to show us the size of motorcycles? That was never really a big issue. Again, I think that the man did an enviable thing. He went online, he looked with all kinds of different databases and so forth, tried to find a motorcycle that looked closest to what he would call looking like the motorcycle that he'd seen on the trail, and submitted that forthwith to the police. And you interviewed them and looked at it. I don't think it's a matter of just size. Now that it totally doesn't look like, or significantly doesn't look like Mr. VanCallis' right now, we hear some indication that maybe it was just not for size. That doesn't make common sense. It's not credible, and that's not consistent. I think Mr. Stein wanted help. His wife just testified that she's very absorbed in the case, and it was just for size he kind of went along. He didn't deviate in anything else. Then we had Special Agent Hess, and Special Agent Hess was the person that did the telephone activity, if you remember. And when he does that telephone activity, the same thing. He's supposed to take the calls and plot them. He indicated to you on those maps that show these little circles that they're just indicating direction, not coverage area. He also indicated to you, I believe, that the area was 0.6 miles, that sector 777, the tower that you referred to, if you remember back from your testimony, could go either way as far as the signal goes. We know that from Marathon gas station to where the trail is at, actually the area where Ms. Millsap was found, is less than a half a mile. So what does that mean? That means that anybody that's made at the Marathon gas station would have been on the same tower, number 777, according to Special Agent Hess. They're just saying, hey, we didn't find anything where they're like in total opposites. We didn't find them together either. Mr. VanCallis has been consistent, has been credible, and he makes common sense in what has been his position to Detective Packman from day one. Remember when he showed up, he said, yes, that's my bike, take a picture of it if you want. Yes, that's my helmet, take a picture of it if you want. Here are my shoes, here are my clothes, here's my body, here's my marks on my leg from cleaning the dog cage. And more important than that, he told him, he said, yes, I was in Armada. But I passed through it, I was going out with my brothers, and I went by Muse's house, and I also went by the Tim Hortons, and then eventually to my brothers. Ladies and gentlemen, we have not heard one iota of testimony that conflicts with what Mr. VanCallis had stated from the beginning. If anything, if you remember, we had a fight to get that marathon video in there. There was objections, and then all of a sudden it wouldn't play. If you remember, we had to wait a while and get Trooper Packman back in here. Because if anything, I think that marathon video shows a lot more that's consistent with Mr. VanCallis' innocence than it does with guilt. It shows him there at 6:17. When you go back and look at that Fitbit, April is at the trail at 6:17. And Mr. VanCallis is over here making the turn to go here, so she's way over here on the trail. He's actually north of her. So then, by the time he's over here, she's going further down the trail. You look at the Fitbit, and you'll see what I'm talking about. So he could not have seen it. That could not have been the motivation. So, oh my God, I think I'm going to try to, hook up with this young lady or something. Second thing, the same thing, the no left turn sign. It's no left turn says you see the bike come back, turn around, go there, and you see it go in the same direction. You don't hear any lies from anybody. Everybody tells you when they get to Donnie's house and so forth like that, these people came, they go to the bathroom, most of these people didn't know. So where would he have cleaned up if he'd have done this? There are people there, not just his brother Donnie. We know that brothers and sisters and family members don't always make the most credible witnesses because they have obviously some love and emotion for the person. But in this particular case, besides his brother, it's his fiancée, Sarah's brother John, his best friend Matt, Samantha, and her friend, Leah, I believe, the one from New York. They're all there. I'm trusting my lady. Nothing unusual. Came in, just wanted to leave for the deer. Didn't use the bathroom, hung out with us the whole time. He wasn't wet, bike wasn't wet, no blood, no clothes, nothing. If anything, he didn't get. toothbrush charger to his brother. Now, ladies and gentlemen, we get to the, I guess, a crux of the case is this whole situation with Crystal. And I think that in his closing argument, Mr. Cataldo somehow tried to imply that maybe I intimidated her or got her to change her answers or nothing. If you remember, I stood up here with some sheets of paper, and every time she gave an answer that was inconsistent with what she had said before, I would refresh her memory and ask her that she'd done that. I didn't say, you don't say this, I'm going to be all over you or something happened. If you remember, I gave her many opportunities. I said, you want to change your mind? Are you intimidated now? Are you upset? Because that's, you know, what she does. What does she do when she's there first, in her first, second, and third statements? And as we know, her statements are being made to state troopers. And I think one time with an FBI agent as well. People that she knows that have guns on them. She's over at her parents' house. And she's going to say she didn't want to tell anything because she was scared. That makes no sense. Ladies and gentlemen, that doesn't pass the common sense test. And then the credibility of it. How credible is that? And also, it doesn't seem to be consistent because she said, you know, all this abuse never came up at the preliminary exam, never came up. This is all new here. This implication that she's some sort of abuser. Even if she were, charge Mr. VanCallis with domestic abuse, if that were the case. She said she never went to the police, no injuries, nothing. So I don't know what kind of abuse. Again, I'm not minimizing it. But her whole story, everything that she says, if you remember about the dogs, she did admit that there was dogs. It took a lot of teeth to get her to admit that those dogs sometimes have accidents on the property. Before she said, oh, no, never. I've never had to clean my shoes. Nobody's ever had to clean their shoes. And when I pointed out that at the preliminary exam, I asked you and you indicated, yes, there are 5 or 6 dogs. And practically everybody in the house had to come in and clean their shoes off after, because they got feces on them. In front of her own words, and she said, yes, that's true. That other thing that she talks about, the hair / hay / straw clump that she was talking about. We had Detective MacArthur. I asked her, she was at the scene, remember at midnight. She got a call about 10, she was there by midnight. She was there the whole time. Or she's been involved in this case the whole time. I asked her, was there any hay at the scene? She said, no, there's no hay there. Again, you don't have to rely on Detective Sergeant MacArthur's recollection of my recitation. Look at the scene pictures. Look at the brutal pictures Mr. Cataldo just showed you not too long ago. Not for the brutality, but look around. There's not a drop of hay or anything like that at all. Look at the pictures of April. There's not a single spot where it looks like even any kind of clump of hair is missing at all. According to Crystal's story of hay and grass and hair being all mixed up in this lump that she found and sat on the windowsill and didn't see again. Even in that, ladies and gentlemen, she's not consistent. Because when I asked her about it here today, in this case, she deviated again from what she said at the exam. Because now she said there was like 2 balls, if you remember. One was hair, one was the grass and the hair. Doesn't make any sense. I mean, how did it go from 1 to 2? That's something very, very, very crucial that you supposedly found in his sleeve. Now, if it's in a pocket, sometimes we all have left things in our pocket and found them inadvertently after the wash. But in a sleeve, and then clothes that have been washed or whatever, it's not sticky or anything. Doesn't make any sense. I don't know where she came up with that whole thing. She came up with things, unfortunately, this time around. Did you saw even when we were sitting here, we were asking different questions. She would tell Mr. Cataldo one thing and tell me another. And finally, it was like 10 after 5 that there's just no point in just, having the lady be uncomfortable here. Hopefully, we made our points to the jury. So all the stuff that Crystal comes up with, including the fact that, remember, she had said that she would frame him, or she had joked with him about framing him with shoes. And she tried real hard again to deny that, but then when I brought that up on the exam, that she had indicated that then, and she said, well, yeah, I could have, would have. But why would you, I mean, you're in a murder case. You're an essential witness. Your recollection of everything is very important, your exact recollection. They would say, well, I could have joked with somebody about framing them with their shoes, and yet here we are, allegations of shoes being a big part of the case against Mr. VanCallis. Allegations that didn't come up till the 4th time, if you remember. That long 5-6 hour interrogation. And again, I asked her here, I said, well, the police never trust me. The police were real nice. Didn't you say with your children and stuff? And yeah. Did you say that you would say that to get out of there? Yes. Did you change your story to accommodate them? Yes. That's her words. That's her words that you folks heard yourself from her exam to here. That's, I mean, talk about inconsistency, talk about lacking common sense, and lacking credibility. That would be a classic example. And again, I'm not knocking the lady. Maybe she's confused, maybe she's nervous, maybe she's got a lot of things going at her. You heard how many times she met with these people. She had basically lost track. Said, oh yeah, I met with the prosecutors, I met with Carter, I believe even the chief perhaps, and went over my testimony and stuff. And if you remember, when I was questioning her, how many times did I say, your answer is almost exactly what you had said then, because she basically was verbally from the exam. So the answers that she chose to answer like that, she thought to answer just like that. But then to try to deny that she was threatened, thinking that her children were taken away, denying about the dog feces and how important that is to this case. You're alleging that a man came in and all of a sudden at night he's cleaning his shoes. And there's an explanation for that. That's an innocent explanation within the confines of the crazy way that, this situation occurred. Come home middle of the night, all these dogs, and you wipe them out. So that's important, and she tried to back away from all of that as well. And then the same thing with the hair. And where she got this, I don't know what she's thinking. But ladies and gentlemen, I think it's exhibit number 74. Ask to look at it. That's the autopsy report. You're free to look at anything that you want. There's not a single mention of any hair missing at all from that young lady's body. So if this is a big enough clump that, would rolled up, would be in the sleeves, survive a wash or whatever, that mixed up with hay and straw under one rendition and then not in another and be separate by itself, I think the medical examiner, if they go into the point where the civilian servant act is there at the autopsy, taking pictures of shoes, you have, I believe, Detective Sergeant McCarthy was present at the autopsy, and a lot of people paying a lot of attention to every single little detail in this case. And you think they're not going to notice that a couple of hairs missing? I don't know where she came up with that, or what that has, just to add to the story is all I can think. Now, speaking of the civilian servant act, that's the gentleman that came in about the foot things. If you remember, he said he was given 11 pairs of shoes, and he basically eliminated 10 right away. And then of the ones that were left, he went this way, that way, try to come up with the best thing that he could. And now they come in and tell you, oh, the scale is 1 to 8. The man that testified, that's what counts. Not the lawyers that get up here and do opening statements and closing arguments. What counts is the evidence. And what you heard from Mr. Servanak himself was a scale of 1 to 5. How many times did you talk about that? And that's when I try to say, in my mathematically challenged mind, I was thinking 4 equals like 80, like 80%, because 5 would be 100%. So I wasn't trying to put words in his mouth, but if you think about it proportionately, even then, he said that there was low incidence of association. There was all sorts of things on it that it didn't match, and so it was just one away from being excluded. And remember, those are shoes that they went out and bought in a different size and in different colors to try to get that based on the tread marks that they saw on the young lady. Let's talk about that too, the tread marks. This is also very important. If you go back and look at those pictures, as unpleasant as they are, with the tread marks on the young lady, you'll see pretty much they look pretty consistent. They look pretty new. They don't seem to be tattered. There don't seem to be any nails or any worn or anything like that. The reason that that's real important is Crystal testified that the shoes that she alleges that Mr. VanCallis had, he wore all the time. The black and white ones that Mr. Cataldo had showed you a few times. I say, oh, those were his favorite shoes. He wore them all the time. Those were his favorite. He wore them all the time. If you remember one thing, if you look at those videos where they're showing him wearing the shoes, he's not wearing them on the bike one single time. He's always wearing them. It's an SUV or something like that. Whatever shoes those are, he has shoes that he wears for nice things and shoes that he wears when he rides the bike. I don't know what kind of shoes those are, but if you go back and look at those, not once do they show these black and white shoes out in the field or out on a bike or anything like that. So how can what Crystal's saying that these black and white shoes that she's attributing to him, that he wears all the time, would have all these characteristics and stuff, all of a sudden when you look at the tread pattern, it's brand new. And if anything, she says he had these shoes for a long time. So go back and look at some of this stuff. The next thing was Lieutenant April, from the Courtroom County Sheriff's Department. He's the gentleman that came in, and he did analysis of the video, from the cost video, from the, which is that gentleman at the house and his motorcycle, took the motorcycle out there, put it back and forth. Me and Mr. Cataldo could spend all day saying, look at the differences, look at the similarities. I will leave that up to you folks when you look at it. But look at that video side to side and stuff. You can, I mean, somebody can see one thing, somebody can see another. And there's no way to identify which like that is. If anything, I think it's extruded. Now, also, you can look at the one that is from Marathon video to that wasn't done in the demonstration that Detective April did with you folks, because it's all evidence. You can look at one piece of evidence versus another piece of evidence and take a look and you see that there's not similarities there either, you know. And they tried their best. They wanted to do everything they could. When you have the homeowner themselves sitting there and telling you, no, I can't tell that way. Yeah, I see this is different and it's taillight bars with the taillights both. Somehow I don't see that there, this. Well, of course you're going to get desperate and try to do what you can. Now, speaking of desperation, I hope I've never implied that these folks have went out and on purpose tried to frame Mr. VanCallis. I think what it was a rush to judgment. I mean, there's a lot of things that make a lot of sense. If you are looking for blue and white motorcycle, you see one. This guy that lives out that way in Armada. And you start looking at him, and then eventually you're talking to his girlfriend or family. She tells you this whole story about him washing his shoes at night. You hear something about debris being taken out. You know he's got a helmet, you know, on his bike that you have in your possession. You get all excited because you got the guy. The exclusionary lesson. And especially because he, unfortunately, is one of those flying spirits that's running around checking out his weed, going by his brother and his friends out. It's not like he went to a movie and he could show you ticket stub. It would be all over him. We could tell you, look, he was watching this movie or he was engaged in this activity and we had him on videotapes. So in that sense, out of that rush to judgment, before the helmet comes back as having any forensic value at all, you heard Detective Sergeant McCarver indicate there were approximately 80 items in our laboratory analysis. We heard from at least 3 or 4 people here, top echelon people, all experts, you know, Michigan State Police, that they looked at the jury the whole time, they know what to do. Very professional. You didn't find anything of any intrinsic forensic value tying the two together. Same with the cell phone technology and so forth. So then what do we get down to? We get down to these desperation tactics where almost every, or a couple of people are asked, did Mr. VanCallis try to change his appearance? No, he never tried to change his appearance from the day that this incident occurred to him, the day he's arrested to the day that he looks now. In addition to which, of course, he's lost some weight, but that's who wouldn't under these circumstances. But also, the same thing about changing a motorcycle. How many times does Crystal ask and other people, oh yeah, he changed his motorcycle, then you change his fender and all that, you know why? Out of a desperate measure to try to make you folks think that that occurred sometime between July 24th and his arrest on the 30th. And we heard unequivocally that not at all. Whatever changes occurred when he bought that bike on Craigslist and then he modified it in color and performance to the way that he wanted. Nothing to do with that. So these kind of desperation tactics have to tell you, I don't think they have a whole lot of confidence in their own lack of evidence, trying to do the best they can. So who doesn't want to make Ms. Millsap happy? I wish there was anything in the world I could do. I would, short of giving her one of my daughters, I would do anything in the world I could do for Ms. Millsap, for what's happening. I think that's natural for all of us. I'm sure you folks want to help, and that's a big component of it. Now, speaking along also that desperation, if you remember, I asked Jason April and maybe another officer a couple of times about the shoes. Remember, I said, look, these are clean shoes, these black and white shoes. Oh, no, we can't tell if they're clean or dirty, or no, I can't tell from that, the resolution's not good enough, it's not big enough, it's a black and white picture. If you vaguely remember that, but if you remember in your notes. Now, all of a sudden, when the prosecution asked him, Mr. VanCallis wouldn't throw those shoes away, would he? Those look like new shoes. Oh, no, they're brand new, they're not a speck on them. Same pictures, same resolution, same questions asked by another person. And all of a sudden, now you can tell if they're clean or if they're dirty, if they ought to be thrown away or if they ought to be kept. We have a lot more in common than you would think that we don't, us as the prosecution and the defense. You've noticed in one thing in this case, I don't think you heard me object to hardly anything. And it's not because I'm a wuss and don't know how to do my job or not going to get up there. It's because these folks have been very, very diligent and very professional in providing us all the discovery. Every single picture, every single document, every single anything else that came in this case was provided to me in enough time to take a look at it, question it if I needed, and that's because of their professionalism, for which I commend them. And they handed everything over, and we were able to look at that and say, okay, that's fine. We had no objections, so I just went through something. That's why I think we're at 188 exhibits in this case. You folks are free to ask to look at any of them. Those are all exhibits. And I think there will be jury instruction to this case, but that exhibits that come in, you can look at them for anything. Doesn't mean that because Mr. Cataldo put them in, that you could only look at it for his case or mine. If they showed you something that, works to our benefit, that's free. And if we were to present an exhibit and it showed something to their benefit, you're also free to do that. Now, another thing about Mary Stein, this will, may come up here. I got to thinking about this. If you remember, she indicated, and I think Amy Spinella indicated as well, that the motorcycle had a blue and white license plate. If you look at the pictures of the motorcycle, Mr. VanCallis' motorcycles plates are orange. Now, we have people indicating, well, maybe blue and white could be similar, maybe a dog that's white and gray could be similar to a dog that's black. I think it's awful hard to mistake blue and white plates with orange plates. That's another very strong thing that came from Mary Stein as well as Amy Spinella. Remember now, we're talking according to Detective Sergeant MacArthur, there's approximately 111,000 motorcycles registered. And I don't want to speak for her, I don't know if she meant the Tri-County area or the whole area that they looked at, a lot bigger than Armada. There's an awful lot of motorcycles. So think back, next time you're thinking, what are the chances to see a blue and white motorcycle? Is it that unusual a color? Is it that crazy? Mr. Cataldo in his closing indicated a couple of times, oh, Mr. VanCallis' bike is unique. He did this, he did that, he changed this, he changed that. He has two different fender colors. Well, I would think that would stand to reason that if that were the case, people would have had a better time identifying it as a unique bike. And you would have had a little bit more precise testimony as to what kind of bike it is instead of black, this, fenders, not fenders, or whatever. In addition to which, let's get back to Mr. Doug Stein. He certainly would have been in a position to say, no, fenders were different colors, this was like this was like that, he was stood up. He focused, actually, maybe his engineering background or whatever, he was pretty focused on much more on the bike. He didn't recall most of the other things. So when we talk about commonalities that we have, that's part of the reason why you haven't seen a whole lot of argument. The law is the law. Her Honor will give you the law, and you folks will go back there and decide what the facts are in this case. And unless at the 12 of you, they go back to decide unanimously that Mr. VanCallis is guilty, he is to be found not guilty of the charges. And that is what you're charged with doing. We have all taken oath to defend the same Constitution. The Constitution requires it. If you're thinking in our case, well, this defense attorney's coming up here trying to bamboozle us, I haven't bamboozled you about anything. I've directed you to evidence that's come in and encouraged you to look at it at your leisure and at your time. But I do want to remind you of a couple of things. First of all, we had a kind of mass hysteria in this country at one time around 1692, I believe, and 1693, and that's when we had the Salem witch trials, where somebody would just say, oh, I think this person's a witch. And we would think right now, how can that result in something so bad? 20 people got executed. And 14 of them were women. 5 more died in jail waiting to be determined if they're witches or not, just because of the conditions and so forth. So these things happen. It's unfortunate that, I'm not saying that this is per se a witch hunt, but that to make a decision based on hysteria. When I'm done, ladies and gentlemen, Mr. Cataldo will get a chance to get back up here, as he has a right to do and an obligation, and he will continue. I would not get any more chances to get back up there. So whatever he gets up there and says, I can doodle and make all the notes I want, is going to be fruitless because I'm not going to be able to come back and address them before he falls. So I'm anticipating if he gets up here and shows you some more gruesome pictures and takes a helmet and beats a few things, maybe stomps some things, maybe throws some boxes around and all that kind of stuff. If you can't, send him some writings. Say, show us some evidence. That's why we're here. This is code of law. And in closing, I just want to say two things. One is that when you folks do go back and make a decision, whatever it is, if you would talk to us attorneys, we would appreciate that. Sometimes the jurors go back after they make a decision, they don't have to talk to anybody, and sometimes they're willing to talk to one party or not the other, but at least speaking for myself, whatever your decision is, it's not going to be any kind of argument or anything, just talking, but I would welcome that if you would just let the judge and the bailiff know. And the second thing is this, ladies and gentlemen, we can sit here and look at the brutality of this crime, look at Ms. Millsap, and we could relate, as Mr. Cataldo said, this could be your daughter or anybody's daughter in Armada or anything. Lack of evidence. Lack of evidence tying in this brutality with this person. And that's much easier said than done. Now, there's a time where they said, okay, they came for black people, I didn't care because I wasn't black. They came for gay people, I didn't care because I wasn't gay. They came for Jewish people, I didn't care because I wasn't Jewish. And one day they came for me and there was nobody left to care. Ladies and gentlemen, you have just as much a duty to uphold the Constitution and the laws that her honor is going to get you. And I think that if you apply those appropriately, with your good conscience, you will find that Mr. VanCallis is not guilty of the charges that are being placed against him. Thank you.
Mr. Cataldo, anything in rebuttal?
Very quickly.
I don't think we've ever argued 1 second in this case that Mr. VanCallis left that gas station and saw her and followed her down to the path. That's not what the app shows. The story has always been he met her on the app because when he accelerated down and got to Willie's path, she was already there. Never was that a part of our case. And also, I'd like to think that the three of us didn't pick 12 or 14 sheep, that you would take the word of a retired trooper as what his thoughts of eyewitness testimony were, instead of the instructions and your own common sense of what you saw. Finally, some say that Jesus turned water into wine. I've never seen anybody that indicated they could change oil into feces. The defense is asking you for a miracle. I'm not asking you for a leap of faith. I'm asking you to take a look at the evidence that I've presented in this case. I'm asking you to take a look at everything that was done by law enforcement. I'm asking you for justice for April Millsap. What I am asking you to do is convict James VanCallis on every count for the brutal murder of April Millsap.
So, ladies and gentlemen, I am going to have my deputy hand to you the jury instructions that I will now read to you. These are for you to take notes on if you'd like. They're yours and yours alone. I'm going to also ask the deputy to give I redid the jury verdict form, gentlemen, only to include the case caption. So please review it and make sure it is appropriate, because I do want the original verdict form to indicate the case caption. Anyone in the audience, the instructions, it'll take me about 15 minutes to read. It's all about the law. You're free to leave if you'd like at this point. And if you are going to leave, I would appreciate if you would leave now, only because I do not like to be distracted when reading the instructions. And you're obviously more than welcome to stay. Gentlemen, I would hope that you're following through with the instructions with me. And at any point I make an error in my reading, it'll take a while, and sometimes I do miss a word. Stop me immediately. You have enough copies? All right. So members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I will instruct the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence in my instructions on the law. You must not let sympathy or prejudice influence your decision. As jurors, you must decide what the facts of this case are. This is your job and no one else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of this case are, to apply the law as I give it to you, and in that way decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that he did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that he is charged with more than one crime is not evidence. The lawyer's statements, arguments, and commentary are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial of excluded evidence that was offered or stricken testimony that was heard, do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have based on the race, gender, or national origin of the witness. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that may have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. The prosecution has introduced evidence of a statement that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must find that the defendant actually made the statement as given to you. If you find that the defendant did make the statement, you may give the statement whatever weight you believe, any weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence, can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. There has been some evidence that the defendant ran away and hid after the alleged crime. This evidence does not prove guilt. A person may run or hide for innocent reasons, such as panic, mistake, or fear. However, a person may also run or hide because of a consciousness of guilt. You must decide whether the evidence is true, and if true, whether it shows that the defendant had a guilty state of mind. If you believe that a witness previously made a statement inconsistent with his or her testimony at this trial, the only purpose for which that earlier statement can be considered by you is in deciding whether the witness testified truthfully in court. The earlier statement is not evidence that what the witness said earlier is true. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecution does not have to prove that the defendant had a reason to commit the alleged crime. He only has to show that the defendant actually committed the crime and that he meant to do so. The testimony of Michael Sage was read into this trial because he was not available. This testimony was taken under oath at an earlier hearing. You should consider this testimony in the same way you consider any other testimony you have heard in court. You've heard testimony about the use of a tracking dog. You must consider tracking dog evidence with great care, and remember that it has little value as proof. Even if you decide that it is reliable, you must not convict the defendant based only on the tracking dog evidence. There must be other evidence that the defendant is guilty. The defendant's intent may be proved by what he said, what he did, how he did it, or by any other fact and circumstances in evidence. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You have heard that a lawyer talked to one of the witnesses. There is nothing wrong with this. A lawyer may talk to witnesses to find out what the witness knows about the case and what the witness's testimony will be. You have heard testimony from the following witnesses. FBI Special Agent Matthew Zentz, who has given you his opinion as an expert in the field of digital forensics and computers and cellular telephones. Dr. Mary Petrangelo, who has given you her opinion as an expert in the field of forensic pathology. Monica Burlsky, who has given you her opinion as an expert in the field of forensic biology and DNA analysis. Andrea Havelson Young, who has given you her opinion as an expert in the field of forensic biology and DNA analysis. Detective Wade Higgison, who has given you his opinion as an expert in the field of computer and cellular telephone forensics. FBI Special Agent Christopher Hess, who has given you his opinion as an expert in the field of historical cellular telephone analysis. Cynthia Edwards, who has given you her opinion as an expert in the field of latent fingerprint examination. And Edward Cervenak, who has given you his opinion as an expert in the field of forensic treadwear analysis. Experts are allowed to give opinions in court about matters they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts he or she gave for the opinion and whether those facts are true. You should also think about the expert's qualifications and whether their opinion makes sense when you think about the other evidence in the case. You have heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witnesses. One of the issues in this case is the identification of the defendant as the person who committed the crime. The prosecutor must prove beyond a reasonable doubt that the crime was committed and that the defendant was the person who committed it. In deciding how dependable an identification is, think about such things as how good a chance the witness had to see the offender at the time, how long the witness was watching, whether the witness had seen or known the offender before, how far away the witness was, whether the area was well lighted, and the witness's state of mind at the time. Also, think about the circumstances at the time of the identification, such as how much time had passed since the crime, how sure the witness was about the identification, and the witness's state of mind during the identification. You may also consider any times that the witness failed to identify the defendant or made an identification or gave a description that did not agree with his or her identification of the defendant during trial. You should examine the witness's identification testimony carefully. You may consider whether other evidence supports the identification, whether it supports the identification, because then it may be more reliable. However, you may use the identification testimony alone to convict the defendant as long as you believe the testimony and you find that it proves beyond a reasonable doubt that the defendant was the person who committed the crime. The defendant is charged with the crime of first-degree premeditated murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of April Dawn Millsap. That is, that April Millsap died as a result of blunt force trauma and asphyxia due to neck compression. Second, that the defendant intended to kill April Millsap. Third, that this intent to kill was premeditated. That is, thought out beforehand. Fourth, that the killing was deliberate, which means that the defendant considered the pros and cons of the killing and thought about and chose his actions before he did it. there must have been real and substantial reflection for long enough to give a reasonable person a chance to think twice about the intent to kill. The law does not say how much time is needed. It is for you to decide if enough time passed under the circumstances of the case. The killing cannot be the result of a sudden impulse without without thought or reflection. The defendant is charged with the crime of first-degree felony murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of April Dawn Millsap. That is, that April Dawn Millsap died as a result of blunt force trauma and asphyxia due to neck compression. Second, that the defendant had one of these three states of mind. He intended to kill, or he intended to do great bodily harm to April Millsap, or he knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of his actions. Third, that when he did the act that caused the death of April Millsap, the defendant was committing or attempting to commit the crime of larceny and or kidnapping. For the crime of larceny, the prosecutor must prove each of the following elements beyond a reasonable doubt. That the defendant took someone else's property, the property was taken without consent, there was movement of the property, it does not matter whether the defendant actually kept the property. At the time the property was taken, the defendant intended to permanently deprive the owner of the property. For the crime of kidnapping, the prosecutor must prove each of the following elements beyond a reasonable doubt. The defendant forcibly confined or imprisoned April Millsap against her will. The defendant did not have legal authority to confine April Millsap. While he was confining April Millsap, the defendant forcibly moved or caused April Millsap to be moved from one place to another for the purpose of kidnapping or to murder April Millsap. The defendant intended to kidnap or confine April Millsap, and the defendant acted willfully and maliciously. This means that the defendant knew that it was wrong to confine April Millsap and knew that he did not have the legal authority to do so. In determining whether the act causing death occurred while the defendant was kidnapping or attempting to commit the crime of larceny and or kidnapping, you should consider the length of time between the commission of larceny and or kidnapping and the murder, the distance between the scene of the larceny and or kidnapping and the scene of the murder, whether there is a causal connection between the murder and the larceny and or kidnapping, whether there is continuity of action between the larceny and or kidnapping and the murder, and whether the murder was committed during an attempt to escape. You have been instructed on the two types of first-degree murder. Those two types are premeditated murder and felony murder. A verdict in a criminal case must be unanimous. To be unanimous, each of you must agree upon which type of first-degree murder has been proved, or that both types of first-degree murder have been proved. If you return a verdict of guilty of first-degree murder, your unanimous verdict must specify whether all of you have found the defendant guilty of premeditated murder, felony murder, or both. You may also consider the lesser charge of second-degree murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of April Dawn Millsap. That is, that April Millsap died as the result of blunt force trauma and asphyxia due to neck compression. Second, that the defendant had one of these three states of mind. He intended to kill, or he intended to do great bodily harm to April Millsap, or he knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of his actions. The defendant is also charged with the crime of kidnapping. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant forcibly confined or imprisoned April Dawn Millsap against April Dawn Millsap's will. Second, that the defendant did not have legal authority to confine April Dawn Millsap. Third, that while he was confining April Dawn Millsap, the defendant forcibly moved or caused April Dawn Millsap to be moved from one place to another for the purpose of kidnapping or to murder April Dawn Millsap. Fourth, that the defendant intended to kidnap or confine April Dawn Millsap. Fifth, that the defendant acted willfully and maliciously. This means that the defendant knew that it was wrong to confine April Dawn Millsap and knew that he did not have the legal authority to do so. The defendant is also charged with the crime of assault with intent to commit sexual penetration. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant either attempted to commit a battery on April Dawn Millsap or did an act that would cause a reasonable person to fear or apprehend an immediate battery. A battery is a forceful or violent touching of the person or something closely connected with the person of another. Second, that the defendant intended either to injure April Millsap or intended to make her reasonably fear an immediate battery. Third, that that at the time the defendant had the ability to commit a battery, appeared to have the ability, or thought he had the ability. Fourth, that when the defendant assaulted April Millsap, he intended to commit a sexual act involving criminal sexual penetration. This means that the defendant must have intended some actual entry into April Millsap's vaginal opening, anal opening, and or mouth with his penis, finger, and or tongue. It is not required that the defendant actually began to commit the sexual act. To prove this charge, the prosecutor must prove that the defendant made an attempt or a threat while intending to commit the act. An actual touching or penetration is not required. To prove this charge, the prosecutor must prove that the defendant committed the assault and intended to commit criminal sexual penetration. You must think about all the evidence in deciding what the defendant's state of mind was at the time of the alleged killing. The defendant's state of mind may be inferred from the kind of weapon used, the type of wounds inflicted, the acts and words of the defendant, and any other circumstances surrounding the alleged killing. Premeditation and deliberation may be inferred from any actions of the defendant which show planning or from any other circumstances surrounding the killing. The prosecutor need not prove a motive for the killing, but you may consider evidence of motive in deciding if there was premeditation and deliberation. Motive by itself does not prove premeditation and deliberation. The prosecutor must also prove beyond a reasonable doubt that the crimes occurred on or about July 24, 2014, within Macomb County. Possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. When you go to the jury room, you will be provided with written copies of the final jury instructions. Obviously, you have them. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. If you have any questions about the jury instructions before you begin deliberations or questions about the instructions that arise during deliberations, you may submit them in writing the envelope doesn't have to be sealed. Submit them in writing and knock on the door, and the court officer will come and take the note from you. If you want to communicate with me while you are in the jury room, please have your foreperson write a note, knock on the door, and the court officer will come and get it from you. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may use your notes in the full instructions. If you want to look at any or all of the reference documents or exhibits that have been admitted, just ask for them. When you go to the jury room, you will be given, well, that's redundant. Now, the defendant is charged with 4 counts. That is, with the crimes of first-degree premeditated murder, first-degree felony murder, kidnapping, and assault with intent to commit sexual penetration. These are separate crimes, and the prosecutor is charging that the defendant committed each of them. You must consider each crime separately in light of all the evidence in the case. You may find the defendant guilty of all or any combination of these crimes or not guilty. You have attached a verdict form. Basically, that is the verdict form, but I do have an original for you with the case caption. The original verdict form reads, "The people of the state of Michigan versus James Donald VanCallis." You may return only one verdict on this charge, count 1, first-degree premeditated murder. You have 3 options: not guilty, guilty of first-degree premeditated murder, guilty of lesser offense of second-degree murder. As to count 2, you may return only one verdict on this charge, first-degree felony murder. You have an option of not guilty, guilty of first-degree felony murder, guilty of lesser offense of second-degree murder. You may return only one verdict on the charge of kidnapping. You have an option of not guilty or an option of guilty. You may turn only one verdict on this charge, and that is the charge of assault with intent to commit sexual penetration. You have an option of not guilty and an option of guilty. It is necessary on my original form that the foreperson please sign and date that form. When you reach your verdict, I am telling the foreperson, whomever that may be, that you should be folding that verdict form in half when you enter this courtroom. At the beginning of the trial, I indicated to you that we would remove 2 of you.
Your Honor, may we approach maybe an error of one discovery?
You should have stopped me immediately, as soon
Well,
as.
I don't have a copy to place it. It's on the way.
when the instructions were given to me, you were originally given your instructions, and you still have your packets, correct? And inside your packets, you have a definition. And if you have a pen, write it down if you left your original packets in the jury room. You were read a definition on 16.4, and this number's on top of the instructions. And you were read a definition on 19.1. So 16.4 is the definition of first-degree felony murder. 19.1 is the definition of kidnapping. Now, I want you to take the packet that I gave you, and I want each of you to remove the definition that I read in 19.2. Everybody remove that 19.2 that I just gave to you. And the deputy's going to come and collect it from each of you. Gentlemen, am I also having them remove 16.4? The kidnapping felony murder? And also remove the 16.4 that I read to you. So two of them you're removing, 19.2 and 16.4. 19.2, 16.4. Just two of them. No, you keep your 16.4B. I want 16.4 and 19.2. That's it. $16.4, 19.2. 16.4 is felony, first-degree felony murder. 19.2 is kidnapping. All right, we got everybody's? Okay, so now we've got everybody's. I am going to read to you those two instructions that are in your original packet. So you go back to the jury room, you have this instruction, but by law I have to reread it to you. You are to disregard whatever you remember from my reading of the ones that we just took away. So you do have 16.4 and you do have 19.1 in your original packet. So jury instruction 16.4, first-degree felony murder. The defendant is charged with first-degree felony murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of April Dawn Millsap. That is, that April Dawn Millsap died as a result of blunt head trauma and asphyxia due to neck compression. Second, that the defendant had one of these three states of mind. He intended to kill, or he intended to do great bodily harm to April Dawn Millsap, or he knowingly created a very high risk of death or great bodily harm, knowing that death or harm would be the likely result of his actions. Third, that when he did the act that caused the death of April Dawn Millsap, the defendant was committing or attempting to commit the crime of larceny and or kidnapping. A larceny is the taking and movement of someone else's property or money with the intent to take it away from that person permanently. For the crime of kidnapping, the prosecutor must prove, first, that the defendant knowingly restrained another person. Restrain means to restrict a person's movement or to confine the person so as to interfere with the person's liberty without the person's consent or without legal authority. The restraint does not have to exist for any particular length of time and may be related or incidental to the commission of other criminal acts. Second, by doing so, the defendant must have intended to engage in criminal sexual penetration or criminal sexual contact with April Dawn Millsap, a 14-year-old child. Fourth, that the killing was not justified, excused, or done under circumstances that reduced it to a lesser crime. Jury instruction, criminal jury instruction 19.1, kidnapping, reads, the defendant is charged with the crime of kidnapping. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant knowingly restrained another person. Restrain means to restrict a person's movement or to confine the person so as to interfere with that person's liberty without that person's consent or without legal authority. The restraint does not have to exist for any particular length of time and may be related or incidental to the commission of other criminal acts. Second, by doing so, the defendant must have intended to engage in criminal sexual penetration or criminal sexual contact with April Dawn Millsap, a 14-year-old child. So let's get back to, we have 14 jurors. Initially, I told you we would reduce you to 12. We do this by a blind draw process. The clerk has her box, and inside of her little box are seat numbers. So we have seat numbers 1 through 14. She's now removed 2. 2 of you will be removed from the beginning of deliberations. When your seat number is called, please remain seated.
First juror would be juror in seat 10, juror number 375. And juror in seat 4, juror number 480.
So, folks, you are still considered jurors in this case. You will remain jurors in this case until you get a phone call from us that we either need you back or that the case has concluded. Please give the deputy, when you leave in about 2 seconds, maybe 5, your phone number where we can always reach you throughout this process, and that's inclusive of today as well as Monday and through whatever time it's going to take. As you are still considered jurors, you are still excused from work in case we need to call you. I am not going to tell you not to go, but you do have your excuse because you are still considered jurors. I want to thank you. I know this has been a long process, and we may not see each other again, and I would ask that you also refrain from not watching any news accounts, listening to anything, or reading anything. You are now excused. So you two can leave, and the deputy will get your phone numbers. Now, the rest of you, it's lunchtime. You might be hungry. If you want to go to lunch, you're free to go to lunch before you begin your deliberations. Please don't take any longer than an hour. When you come back, if you don't choose your foreperson before you leave, that's your first job, your first responsibility is to get your foreperson. You're free to take breaks whenever you'd like. Please don't take longer than 15 or 20 minutes. I would like to continue with the process of taking breaks with you being escorted if you need to smoke down to the either cafeteria, you can't smoke there, but outside if you need to have your cigarettes. And I would, and I'm going to instruct the jury, have you escorted down to our cafeteria today for lunch. And you can have your lunch there in the cafeteria. You're free to stay today as long as you'd like. And I would encourage you, if you want to stay longer than 5, that's fine with me. I'll stay as long as you'd like. If you continue deliberating until Monday, you'll return Monday at 9 a.m. to resume your deliberations. If you have questions, you need to reduce them to writing in a note, knock on the door, give it to the deputy. Be patient. Sometimes we're not going to hear the knock. You got to knock pretty loud, and we'll get to you. If you want to see the evidence, again, you need to ask for it. We will have all the evidence together. If it becomes necessary for you to view anything on the screen that you want to see enlarged, because I do believe you're going to be given pictures of everything, but if you'd like to see it on the large screen, we will be able to bring you out and allow you to do that again. If you need to see any type of video, again, we will bring you out into the courtroom and we will all view it together. Okay? I'm just going to wait now for him to return. So please, when you get in that room, you get your foreperson, and then decide how long you want to go to lunch, and then go downstairs. Do any of you have any concerns about like moving your car or anything that you might want to do at lunch? Because I'm making you have it downstairs.
I have to get something out of my vehicle, but I'm parked right in front.
Okay, well, I'll allow you to go get it. I would like for them to have their lunch down in our cafeteria to avoid anybody in the lobby. So they will be escorted down to the cafeteria to get their lunch if they choose to eat. If not, they can stay here. The gentleman in seat number 3 needs to run out to his car to get something from his car. Lunch? No? Okay. So you can begin your deliberations, folks. Thank you. So, gentlemen, as it relates to the jury instructions, were you satisfied with the corrections that were made and as the jury instructions were read?
People are satisfied.
Defense is satisfied as well, Your Honor.
For the audience's purposes, it's very important, folks. I know that you want to know what the verdict is, and I know that you're going to be in the building, but it's very important that you avoid the jurors. If you see them, please stop talking. If you see anyone with a jury tag, please stop talking. And I know you want to talk, and I know that you want to do what you're going to do, but it's so important that we try to keep them secluded from you. So if they're in the lobby when they're leaving or whatever it may be, please try your best to respect them and not say anything out loud that might affect their decision-making process. I promise you that when I get the notice that a verdict has been reached, I will give 1/2 hour to all of you to return, and I will wait 1/2 hour before I bring the jury back in to take their verdict. So, if you want to work something out with the prosecutor or the defense attorney as to getting a phone call and returning so you don't have to be around the building, you do that. If you want to stay around the building, certainly that is your prerogative. It is a public building. And I want to thank you all because for the most part everyone has been very gracious with understanding the court process and being considerate of the attorneys throughout this process as well as Mr. VanCallis. Please, let's remain that way. It's important to our process that you continue to respect each other in this building. And again, I want to thank you all for your courtesy. We will, gentlemen, make sure I have a phone number to reach you, and you're free to leave. Just make sure you're within 1/2 hour of the building. The attorneys, I'd suggest maybe 10 minutes because we might have legal issues that we'll have to deal with throughout the deliberation. Thank you. Make sure you have all the evidence on a file. Guys, Mr. Cataldo, Bills, make sure we get the evidence on one pile, make sure it's all ready.
Got it in numerical order and everything. We're all set to go with a set of a log so people can look through and find it all.
Gentlemen from the media, if you want to give my clerk your phone number, we will call you if you want us to. And I will wait 1/2 hour, that's it.